Hi, and thanks for joining me for today's legal Q&A. All right, let's get right to it. So the first question we have here is, where and who do I go to? I had put in 130 days worth of work with a union, and all I needed was 90. But I was fired, and I went to unemployment, and they said that I wasn't qualified. What do I do? Okay, so when you're a member of a union, you typically have a union attorney who's appointed to help you. It's somebody that is hired by and provided by the union so that you have someone to go to. So in circumstances where you have issues with your employer and you're in a unionized job, before you go out and seek an independent attorney to retain, why don't you first go to your union shop steward, talk to him or her and explain the situation. Then set up an appointment with the attorney who is provided by the union. You're going to save yourself money because most often many of the legal fees that are associated with disputes in areas like unemployment or wages or overtime that's not being paid within a union can be dealt with directly and very cheaply, if not free, by the union attorney. Now, if you go to the union attorney and he or she cannot help you or will not help you, then of course you need to retain outside counsel. But that's where you go first, so give that a shot. Or the next question is, how do I get my gun back once a temporary restraining order was dismissed? I'm an officer and I have not received my service weapon since my dismissal in 2013. So this is an individual who was suspended from the police force, and as part of the investigation and the issues that were going, and I'm not going to get into that part of the question, but suffice it to say that the individual had their firearm taken away until they went through psych evaluations and other testing. And at the conclusion of the testing, they realized that everything was fine and it was misinformation, and so the individual officer was cleared of all charges. And this temporary restraining order was a result of another individual who was involved in this. But at the end of the day, the officer's cleared, and now the officer wants his or her, I'm not going to tell you if it's a man or a woman, his or her firearm back. And what should he or she do? So in reading the question and getting into the details, I've learned that he or she has gone through all of the administrative channels to try to recover his or her firearm. And each time this person went through the next administrative channel, they were always told, yes, we're doing it, it'll be cleared in a minute, and then nothing happens. So the question is, well, now what do I do and how do I get my gun back? Now, most times I'll tell you that the way to do it is go through the proper administrative channels, but in this case, when your administrative remedies are exhausted and you've not gotten anywhere, you have to hire an outside lawyer. An outside lawyer can help you approach the municipality, the administrative agencies, and if need be, file a lawsuit with the courts to make sure that your civil rights and your rights as a free and cleared police officer are not infringed upon. So really at this point, the only thing to do is to go out and retain an attorney. All right, next one. This is an interesting one. This is a question that comes up often. This is an individual who handled a breach of contract case pro se, meaning they represented themselves. And the question is, what expenses am I entitled to? I won a breach of contract case and a fraud case in New Jersey, and I want to know what expenses I'm entitled to get reimbursed for from the defendant. Does it include expert witness expenses? This is a really good question, and it's a common one. So in other videos, I've explained when you can recover certain costs and fees out of a lawsuit. Now, the simple answer to this question is you are entitled to recover costs, but I need more information before I can give you a firm answer because I don't know how this individual won their case. I don't know if the case was won on summary judgment and there's a court order. I don't know if it was a jury verdict or a bench trial and the judge issued a decision. because without knowing that, I can't tell whether or not there was an award for fraud, an award for breach of contract. Because typically in breach of contract cases, you are entitled to whatever the disputed contract amount is, and then you're entitled to recover your costs. What are costs? Well, clearly, since this person represented himself pro se, they're not attorney's fees. Attorney's fees are always separate from costs. Costs and expenses are the actual amounts of money that you expended in connection with certain things related to your lawsuit. For example, filing the complaint, serving the defendant, expert witness fees, paying a court reporter when you have a deposition. So all of those things are expenses, and most often you're able to recover them from the defendant, but it really depends on the specific circumstances. I don't know if this is a special civil case. I don't know if this is a superior court case. I don't know what the ruling is by the court, and therefore I can't say with certainty whether or not they're entitled to expenses. But, that's something that you would need to look into. Look at the court documents. See what document you have. See if the court order says that the defendant is ordered to pay, X amount in recovery plus expenses. All right, next one. This is a unique question. My sister's husband has created a problem with my sister's married life, and now she wants to move to the USA from Canada. Is there a way that my sister can stop her from entering the USA? How about filing a case that she is a threat to her and her children? Okay, first, there is no way to prevent someone from applying for a visa or citizenship into the United States simply because he or she has caused trouble for you in, your private life. It's a decision made by the government and the immigration department as to whether or not the individual applying qualifies. So, no, you cannot stop this person from entering the country. Now, taking it further and looking at the next part of the question, which is, can I file a case saying that she's a threat to her and her children? There's no cause of action here unless she's done something. If she has done something and has triggered some sort of legal cause of action, assault, battery, defamation, she was negligent and somebody was injured, you can't just create a case simply to prevent someone from entering the country. So the simple answer after a long explanation is no. There's nothing you can do to prevent her from coming into the country. Once the individual is here and, she's creating problems and she's coming to the house, well, that's a different story. If there are problems, perhaps you can get a temporary restraining order because the individual now has to comply with U.S. law. So that's a separate issue. But can you stop them from coming into the country? The answer is no. Okay. Next one is, can I sue my outpatient program if they said I tested positive for drugs in my urine test, but I have proof that it was negative? So here we have a urine test that was provided to an individual's probation officer, and it claimed to test positive for cocaine, but ultimately what happened was they had mixed up the samples. So now this individual who was on probation, and obviously the positive cocaine test violated the probation, this person was put in jail. Now they were only in jail overnight, but the next morning they were released, but they were released because the testing facility realized they had mixed up the samples. So can you sue, and who can you sue? Without knowing more, can you sue the police? No. First of all, you can sue police in other circumstances, but police and municipal entities have various immunities afforded to them. And in this case, the police were acting appropriately under the circumstances because of the positive test. So they didn't violate his civil rights. They arrested him. I assume he was Mirandized and he was taken into custody. So they acted appropriately. How about the outpatient testing facility? Do you have a cause of action against them? I would say yes. What you can recover is a different story, but were they negligent? Is there liability for negligence because they mixed up the tests? And the answer is yes. A, remember the elements of negligence. They owed a duty of care. They breached the duty of care by mixing up the samples. You had damages. I mean, what are your damages? Well, you spent the night in jail, and there's a proximate or direct cause between their breach of duty and your damages. So, can you sue? Yes. Are you going to recover a lot of money? It's hard to say. It's hard to value your time in jail, but you certainly should be entitled to something, and you won't really know what that is until you sue them. Oftentimes in cases like this, the facility, if they admit that they were negligent, which they do, and that's how the individual was released from custody the following day, they'll settle with you relatively quickly. All right, and today's final question is, can I be fired and denied unemployment if I fell asleep at work in an office? So this is an individual who is at work and was tired one day and decided that they were going to go into a vacant office and take a nap. Now, the person was supposed to be working, so it's not as if the person was on a lunch break or had a break and went to go lay down. This is during the course of this person's employment, during the time that this person should be working. And when the boss came in and found the individual not at his or her desk doing what they were supposed to be doing, he said, you're fired. So the first question that has to be asked in a situation like this is, are you a contract employee or are you an at-will employee? And 95% of the time, the answer is, I'm an at-will employee. Most employees in New Jersey, and in the country for that matter, are at-will employees, meaning that they are employed and that their terms of employment are open. They can leave at any time and their employer can fire them at any time. It's not like a contract employee where I sign a contract and I'm going to work for you or with you for a year, right? Major League Baseball players, football players, they sign contracts. So they're not at-will employees, they're contract employees. But most of us are simply at-will employees. And as long as an employer does not fire you for discriminatory reasons, in other words, they're not firing you because of your race, your sexual preference, your creed. They're firing you because they don't like you, you did something that offended them, you're not doing your job well, you're late to work, you're falling asleep on the job, they can fire you. So can you be fired? Yes. You're an at-will employee, you fell asleep at your designated work time, so yes, you can be fired. Now the next question is, can I be denied unemployment? Well, that depends on how long you've been employed with the company, because there's a threshold. There's a minimum amount of weeks that you need to work in order to be qualified for unemployment. We don't know how many weeks this person was employed, so I can't answer that question. However, I will add that when a company terminates an individual, they have an opportunity to dispute unemployment benefits, because the unemployment office, once the individual who was fired files an application, the employer will get that application and they have an opportunity to respond. And if they fire the individual because that person was not doing their job or not doing a good job, they can, advise unemployment of that. And oftentimes there'll be a hearing, and sometimes an unemployment will say, well, this person was fired for cause and therefore is not entitled to unemployment benefits. But that's speculation on my part, because we don't know how long this individual had been employed with the company. So that's it for today. If you have questions about any of the topics we discussed today, or if you want to submit your own question and have it answered on our YouTube channel, you can do so by either posting it in the comment section below, or you can give us a call at 973-949-3770, or email me at info@peterlamontesq.com. We'll answer your questions on our channel, and we'll also email you and let you know when the question will be posted and answered. So I hope that this is educational and informative, and that you're enjoying this segment. If you are enjoying it, please just drop me a note, stick something in the comments so I know that you guys are enjoying what we're doing, and that you find it instructional and informational. I'd appreciate it. So until next time, keep the questions coming. If you've got questions and you want to do it anonymously, give us a call. Don't give us your name. Ask the question, and we'll put it on the YouTube channel. So thanks for joining me, guys. I'll see you next time.